thank everybody, first of all, for sticking around to the end. Hopefully we don't disappoint. And I'm not sure what time the sixth game is with the Red Wings, but hopefully, what time is it? Oh, okay, all right. Well, I'll go as quick as possible. For those of you who are flying out to the game. Okay. I also apologize. I'll be sitting down, not out of disrespect to anybody, but we do have a PowerPoint presentation. And again, this is an informal presentation, so if there's a lot of questions and we deviate, so be it. But I'm Robert Iwrey of the Health Law Partners, and this is Virginia Trzaskoma. She's the Assistant Attorney General who has a number of areas of specialty now, but one of her areas of specialty is healthcare, licensed prosecution on behalf of the Bureau of Health Professions. And her job here is to provide you some insight into how you can avoid seeing her, other than during presentations like today.
So the microphone can pick you up?
I actually have another microphone, so thanks. We're good. Okay. With that being said,
Rob is always prepared.
Again, this information will be provided to you if you desire. Make sure you put your name on the sign-in sheet with an email, and we'll provide all of the outlines and PowerPoint presentations to you. So there's a lot of substantive information in here that I'm not going to go over because it could take hours. And the reality is you probably want to hear more from Virginia than you do from me. But generally speaking, it's the Department of Community Health that governs, in the Bureau of Health Professions within the Department of Community Health, that governs licenses. And there's nearly 400,000 health professionals within 35 healthcare occupations. So it's really a large amount of material that they take care of. The Bureau of Health Professions has three divisions: licensing, regulatory, and the complaint and allegation division. The licensing division is responsible for the applications, for keeping track of CME. Various licensees have different CME requirements, and they have to keep track of those. And a failure to actually accomplish your CME could result in a licensing action for a healthcare provider. The regulatory division, and actually, it's really the complaint and allegation division should come next, because the complaint and allegation division handles the complaints that might come in about a healthcare professional, and if there is a complaint, then the regulatory division could come in and conduct an investigation with regard to that complaint and allegation. And again, I'm going a little fast because I want to get to the meat. Typically, an allegation is filed by a patient. Sometimes you get, unfortunately, ex-spouses that might have an axe to grind or some ulterior motive for filing an allegation. But nonetheless, typical allegations are for quality of care or scope of conduct or scope of practice or the conduct of the licensee. And there's a process that is followed where once the complaint is received and assigned a number, an investigator is assigned to it, and the Bureau will make a determination of whether it's worthy to conduct an investigation or not, and then they conduct an investigation. It has been our experience that typically, if there is a complaint against let's say a physician, the physician is the last to know. In other words, if they think that there's enough information that would warrant investigation, I call it the circle the wagon approach. So here's the target of the physician, and they talk to the complainant, then they talk to maybe office staff if that is pertinent, and they go to everybody else first. And then when they think they have the story, they then go to the physician. And then basically, based upon that information, a report is written, and it will go to, eventually it gets up to the disciplinary subcommittee of the respective board to determine whether or not there's enough information to warrant the issuing of administrative complaint.
As Rob jumps through there, I'm going to interject.
Absolutely.
He knew I would.
By the way, this is kind of like point counterpoint.
Yes.
So.
With regard to circling the wagons, which I disdain the image. He keeps saying they, and the they that is going to come to your office, the they that is going to do the interviews, there's an investigation division, and they have investigators, and that is the Bureau of Health Professions. When those investigators come to your office, most of the time, unlike some of the horror stories I've heard recently, they are very conscientious of the fact that you're running a practice, and they do want to talk to you. Sometimes they come unannounced. More often than not, they've called you. If you don't call an investigator back, they're not going to go away. They're simply going to show up at your office, interrupt your day, scare your patients, and potentially scare you. So that's my idea of what happens frequently is instead of calling or trying to ascertain what this person wants, is that they go on ignore. And then the investigator is forced to either show up at your office unannounced or start talking to your employees unannounced. So you can control the process if you don't put your head in the sand.
And actually, I will agree with you that most of the investigators that I've dealt with, in fact, all of them that I've dealt with, have been very professional. And for example, I have a meeting with one on Thursday. The investigator contacted the physician and said he would like to meet. And what I typically advise my clients is never meet with an investigator without an attorney. But my client contacted me. We, arranged for a mutually convenient time, and certainly we will come prepared and answer all the questions and provide probably additional information so that we're comfortable that the investigator has the full story. But it's even the very first time. You got to remember something. In my opinion, if there's an investigator who is contacting the physician and looking, they've already made some minimal determination that there's enough to warrant expending government resources to send that investigator. I mean, they probably get all kinds of complaints from all different types of people. And I've heard people complain, I'm filing a complaint against this doctor because my back really hurts and they wouldn't give me OxyContin. Okay, obviously the Bureau is not going to send an investigator out to interview the physician with regard to that complaint. But if at some point they've made a determination that it's worth sending an investigator out, at that point in time, because a licensing action, if there is an administrative complaint and it gets to the point where one is filed and action is taken, the range of sanctions available to the respective the respective board at issue, whether it's Board of Medicine or Board of Osteopathy, it can range from a reprimand to revocation of a license. And so, I take that to be very, very serious when they're taking action against your license. And we'll get to it in a second, but people don't also realize that even things like a reprimand or a probation can have devastating effects, because certain things like certain PPOs, you might have a significant third-party payer that will say, well, I think a reprimand is a sanction, and you're going to be departicipated just on that alone. And so I take them very serious. And I also find that if you do your homework right from the beginning and you don't wait till till it's too late, and Virginia and I have had numerous conversations along those lines. If you do your homework from the beginning, dot your I's and cross your T's, a lot of times you can avoid the whole embarrassing, costly, emotionally draining process of a licensing action.
There's a theme that I think you've heard from Mr. Beyer, Mr. Cranmer, and Mr. Afonsi, and you're going to hear from us, and that is it's a lot easier to keep you out of trouble than to get you out of trouble. If someone from the state shows up at your office or is on the other end of your telephone, call your lawyer, at least answer their call. If you don't, it's only going to get worse, whether it's criminal and it's the FBI wanting to know about your finances, or if it's a state investigator with an administrative action. It only gets worse from there if you don't answer. Depending upon what the situation is, if the question is what happens if an investigator is in your office and wants to talk to you, your staff, or someone else, they're there because there's been a complaint that's been filed and that complaint has been authorized to have an investigation. At that point, it's serious. How it ends up, if it's because you've been convicted of healthcare fraud, then, that's very serious in and of itself. But you're going to probably know why they're there. If it's because the accusation is that you've been overprescribing, as Tom and Dan have brought up earlier, and I'll talk about that a little bit, then your best bet at that point is to try to figure out what the accusation is. You don't necessarily have to talk to the investigator right then and there. You can make an appointment to talk to them. You can call your lawyer. The state is going to work with you, contrary to popular belief. We don't have the resources, and I say we as the Bureau of Health Professions, neither nor the AG's office has the resources. We regulate every healthcare profession in the state. That's a whole lot of people.
Yeah, and along those lines, again, I find the investigators to be very cooperative. And the idea is, I can't even think of a time when I haven't met with the investigator, because you don't have to meet with the investigator, but I just find it's an opportunity to try to resolve the matter, and that's what everyone wants, is closure. And so it's a good idea. Again, I advise any of my clients to politely indicate to the investigator that they would like to talk with their attorney, and that their attorney will contact them and arrange for a mutually convenient time to meet. And that is usually what occurs. It's important also to note that complaints, the process can be started not just by a complaint from a patient, but there are also certain statutory duties of reporting that the Bureau of Health Professions receives, and these are included in this slide. For example, a limitation of staff privileges or a change in employment status is the hospital has to report that. And I find that this comes up sometimes in an unusual circumstance where a physician, maybe is practicing at 2 or 3 different hospitals, and one of the hospitals looks like there's some type of disciplinary action, and instead of exercising his or her rights under the bylaws, they say, you know what, I barely do anything at that hospital. I don't even care. Let it go ahead. Well, without challenging that, then there's a change in their staff privileging, which then gets reported to licensure, which then can result in a licensing action. And so you'll see another theme is that the interrelation, the kind of what I call the domino effect. It's very, very important that anytime matters such as staff privileging, criminal, licensing, they're all interrelated. And if one of these issues comes up, it's important that you consult with someone who can kind of look at it from a global perspective and advise you as to the various ramifications of these actions. Another point is that a licensee must notify the department of a criminal conviction or a disciplinary action in another state within 30 days. And
do you want me to jump in here?
Are you going to talk about the Shaw case, or do you want to?
Rob and I will vehemently disagree, and I may have a disagreement with the other gentleman in the room. There is a case named Shaw, S-H-A-H, and that case, Rob and I vehemently disagree on, which may lead you to believe that a conviction in another state is the only thing that you need to report to the state. I would implore you that if you are convicted of a crime anywhere, that you take the bull by the horns, so to speak, and report it. Now, that may trigger an investigation, and I think that Rob and the other gentleman here may disagree with me, but eventually we, as in the Bureau of Health Professions and Licensing, is going to come to realize that you have a conviction. If you have a criminal conviction, the statute, the Public Health Code, provides that pursuant to the criminal conviction, your license can be suspended summarily. That means tomorrow I can go to my office, look you up, see that you have a conviction, and suspend your license. That means you can't practice.
For a felony.
For a felony.
Not for a misdemeanor, though.
Some misdemeanors, depending upon the underlying conduct, also result in summary suspensions. Drug possession, driving under the influence, some other, assaultive crimes. There are things that the boards, as in the Board of Medicine and the Board of Osteopathic Medicine and Surgery, deem more serious, and those crimes may result in a summary suspension. If you don't want that to happen to you, I suggest that perhaps you contact your attorney and that you report that to the licensing division.
And just most states have similar types of provisions, and so the notion of, I have 4 different state licenses, I've got a problem in Michigan, you know what, I'll just leave Michigan, I'll go to California where I'm also licensed, doesn't really work that way. They will follow you, and there's reciprocity in terms of sanctions as well, and so it's kind of important to address each issue as they come up.
I have seen that. I served on the appeal board for one of the insurance company across the country, and I've seen that actually even in Canada, I think somebody lied that something happened in Canada, and that was one reason they suspended the license.
Absolutely.
They did report that, and
the state calls them sister state actions.
Right.
So a sister state, sister country. If we find out you've been sanctioned in Ohio, in California, in Texas, and we find out about it rather than you reporting it to the Michigan Board of Licensure, you can bet that an investigator is going to be on your doorstep sooner or later.
Yeah. I also point out that you just mentioned with insurance, a lot of times you have a duty under each of your third-party payer contracts. If it's a participating provider, you have duty to notify them if you've been convicted of a crime or if you have a licensing action, and you can be departicipated if you don't. And sometimes people ignore that, and the licensing action was pretty minor. For example, I didn't complete all my CME, and then there's a licensing action, and it's just a matter of taking care of it. But then you fail to notify the insurance company, and if they want, they can use that as a basis to departicipate you.
And this is probably also a good point at which I can address the situation where there was a $2,000 Medicaid snafu, for lack of a better term. In that situation, if there was a guilty plea to a felony, the Public Health Code provides that the license shall be suspended. Now, if you knew, for instance, there was a situation where a physician is going to plead guilty to a felony, I have had attorneys, Rob Iwrey, call me and say, I'm doing this in criminal court and I want to have the corollary, knowing there'd be a licensing action. I want to deal with this all at once. I want to have a global agreement. And my plea isn't going to happen until X date, and is going to be sentenced on Y date. And in the interim, let's get the licensing action going so that while that happens, we don't have to have, the summary suspension doesn't have to be such a gap in their practice that they're losing so much money. If they're surgeons, for example, you've reserved, operating rooms, and you have people that depend on you. So in order to facilitate your practice continuing, you can do that, and attorneys have called me.
I want to call to your attention something that happened to me that I indicated before. You say if you were convicted of a felony. In my case, 2 days before the trial, before I was going to the trial, I was ready to go to trial to fight this case. I felt I was innocent. And my attorney said, the Assistant Attorney General, Richard Connischnick, who is now retired, you may know of him, said the felony's been reduced to a misdemeanor. And I told my attorney, hey, that's great. My attorney told me that's great. So I went ahead and I pleaded guilty to a misdemeanor, thinking that this will work out fine. Already I spent $80,000 of my money, approximately, some of it was retirement money, to fight the case. My attorney said, if we go to trial, it'll be $50,000 more at least to solve this. Well, going from a felony to a misdemeanor, I said, that'll be fine. Well, it turns out the felony and the misdemeanor is the same. I'm departicipated from insurance companies.
Sure.
I've been turned down by about 8 employers for jobs because the check would go to the patient, and no employer wants the check to go to the patient for the simple reason that they may not see the check. In an interim, I just felt that when it happened in 2006, Attorney General Mike Cox was on a Medicaid fraud kick. He was going to run. He's running for Attorney General, and he wanted to show the public that he can go after any case. I think he just nitpicked the case. In my case, I think he probably gave instructions to the Assistant Attorney Generals, go after anything. $2,000 over a 5-year period is a small amount when I was willing to pay back this right away, but they said no. I've been active in organized dentistry. I've been president of 3 different dental organizations. I've taught at the dental school. In 45 years of practice, 1 blemish on my record. Right now, I'm trying to get a pardon from the governor. I sent in an application to the parole board last August. It's 10 months. They still haven't voted on it. Supposedly, from what I hear, they're going to vote this month, whether it's for or against. And then it's another 10 months when it gets to the governor's office before the governor signs it.
Right,
So,
Dr.
I'm frustrated.
Right, and I want to make it you actually raised some very good points, and one of the things, first I'm going to protect Virginia in a sense. Obviously, she can't comment about Richard Koenigsegg or Mike Cox or anybody in terms of what they have done or haven't done. But your story, though, certainly underscores, again, the global aspects, the interrelation of all of these different elements that, when you're dealing with somebody at the AG's office, their duty is simply they have a job to do in terms of, like, with Virginia, she's looking at the public health code and a violation. It's not her job to protect a provider against departicipation or criminal or loss of insurance because they got kicked out of the professional society, or loss of board certification, or DEA registration. There's so many different elements that are part of that. But it is important that the attorney that's representing you in fighting that, even on the criminal case, that attorney should be aware, and unfortunately there's a lot of attorneys who are not aware of all of the ramifications, hence what happened to you. Like you're saying, you thought, wow, it's not a felony, it's a misdemeanor, I can live with that because it's not going to really affect my ability to practice, when the reality is, there's all those dominoes that fall as a result of that.
It's absolutely going to affect your practice. And I want to say a couple of things about the attorneys that I'm presenting here with today. A good attorney makes all the difference. A lot of criminal defense attorneys are wonderful. I was a prosecutor for almost 5 years. I have yet to meet a defense counsel that was not as civil and intelligent and well-versed in everything that they did. In licensing, however, I loathe to say that there are a lot of people who think that they practice administrative law, and they don't. If you have someone from the Attorney General's office that's coming to you and saying, I'm talking to you about an administrative licensing action, that is an entirely different thing than a criminal case. You want to have an attorney who is well-versed in administrative law, who understands the ramifications and understands the ripple effect that Rob was just talking about between your third-party payers. What happened to you is what I call the ripple effect. You thought you resolved one thing, and that one thing led to all of these other things congealing to force you to change the way you practice, perhaps prevent you from practicing, and absolutely changing the way that you're going to go about your future employment. All of those things have to be considered when you take any sort of a criminal plea. And if you cannot always rely on the person that's you cannot always rely on one aspect of the law. You cannot always rely on a criminal defense attorney to know everything there is to know about your license. But you should consult with...
Unless you have somebody like Tom who knows all that stuff.
I think he did.
Or Dan.
He worked in the Attorney General's office for 10 years as a prosecuting attorney against Medicaid fraud. And at the time he left, he got a law passed saying that, well, it's not a slap on the wrist. We take the case to court. And I'll mention his name, Max Hoffman of Hudson Law in Lanes.
Okay. Well, you know what? I will do this, and I appreciate we want to get through some of the process, so we can. No. I understand, and hey, you've been through a lot, so afterwards we can have additional discussions about that. But should you unfortunately be faced with an administrative complaint and you're not able to resolve it, there is a process that is followed, and there's plenty of opportunities for resolution, even if there is an administrative complaint. Initially, there's a compliance conference. I take it again. I take every step very seriously. My goal is always to try to resolve it before the next step. So if you can't resolve it with the investigator, an administrative complaint is issued, you then can have a compliance conference where you sit down, the physician sits down with somebody from the Bureau of Health Professions and an attorney, and they try to resolve it at that point. If that is unable to do so, it gets set for a formal hearing before an administrative law judge. You can still then have a settlement conference where it's similar to the compliance, but a lot of times then an assistant attorney general who would be handling the case is also present. You can try to resolve it at that point. Nonetheless, if you can't come to a resolution, you actually have a trial before an administrative law judge with the rules of evidence, and you have witnesses and whatnot. And the administrative law judge is going to then render his or her opinion as to the facts, the law, and what he or she thinks the disposition is. However, he or she will not indicate or recommend a particular sanction. What happens is this whole process that I just described is basically to determine whether or not you violated the Public Health Code. The Public Health Code is a statute. It's very specific, and there's enumerated bases for disciplinary action, and some of them are kind of broad. You generally you failed to adhere to the standard of care. You were negligent. You were unethical. I mean, there's certain, some of them are more specific, but some of them are pretty broad. And so, if you go through to the full hearing, and the administrative law judge basically is just deciding, did you violate the Public Health Code? If the answer is yes, it goes to the disciplinary subcommittee of your respective board. So if you're a DO, it goes to the DO board. If you're MD, it goes to the MD board. And they then have the ability to levy a sanction against your license. Now, you can't really challenge the severity, okay? You can go into circuit court or court of appeals, and you can challenge the finding that there was a violation of the Public Health Code, but you can't challenge the severity of the sanction that was imposed. So what happens is that puts people in a kind of a precarious position, because if you don't take it seriously from the beginning with the compliance conference, with the settlement conference, and try to argue your best case there so that you'll get a reasonable sanction if you violated the Public Health Code, okay? So that you're willing to take some type of responsibility, then you try to take a chance. You go to the administrative law judge, and they find that you did indeed violate the Public Health Code. I generally find that when it gets back to the board says, well, didn't we offer that person a resolution that was reasonable, and they didn't take it? The sanction usually is much harder. And so there is a lot of reason and bases for really trying to resolve it from the beginning, and kind of showing your case right from the beginning. You agree?
I agree I think the sanctions are generally more harsh, because I think that the reasoning is that the disciplinary subcommittee looks at the case and has decided that either A, the licensee is not accepting responsibility. Yes, I committed healthcare fraud, and I was convicted of a felony, but there's a reason. Okay. Or there's not enough mitigating circumstances. You haven't presented. If you think when an investigator shows up at your door, if that happens to you, and if you've chosen to speak with him or her, and you feel that there's been some sort of a very large mistake, you have a very unhappy patient, you just know what this is about, and you happen to be right, I still suggest you call an attorney. But outside of that, and this is me, the person who's going to be representing the Attorney General's office, it's easier for you to have an attorney who can explain to you all the ramifications, because I'm not going to do that. By the time you get to me, the sanction it has already been through a whole lot of process, and by the time you actually talk to an assistant attorney general, we're getting prepared to go to hearing. That's generally where we're at in the process. And so by the time you get to my office, we're generally at the point where we believe that the case isn't solvable most of the time. There are a few exceptions to that, and one of them is overprescribing, and we'll get to that in just a minute.
So as we hear us consistently reiterating, is this notion of there are domino effects, there are collateral consequences. So if there is a licensing action, there is a sanction on your license, okay, it gets reported to a lot of different people. It's part of your permanent record, okay? I can go online, and anyone who has a healthcare license in Michigan, take me 5 seconds to look back to see if you've ever had any discipline. And it's there forever, and it tells you the date, and it tells you what the sanction was and when you complied with it. It's also printed in the disciplinary action report. It also goes to the Office of Financial and Insurance Regulation. It goes to various state and federal agencies, Medicare, Medicaid. We'll find out. It also goes to the Associated Press and UPI, and National Practitioner Data Bank as well. I'm not going to get into we could talk about the National Practitioner Data Bank for 2 hours. It's a very lengthy area to go through. It's important to understand, though, that certain entities cannot query it. Medical malpractice insurance companies are not able to, but hospitals do and are required to upon application for staff privileges, as well as every 2 years. They will query the data bank, and if you've had a licensing action, it's going to come up. It's important to know what's in that data bank report. If you actually have, and that's part of the global resolution as well. If there's this is off topic a little bit, but if there's a staff privilege matter and you're trying to resolve it with the hospital, and there's going to be a report to the data bank, try to make sure you can influence what is reported to the data bank. And also, if the data bank has a report that's inaccurate, there's a whole process that you can follow to try to change that, or at least submit a personal statement that counteracts it, because that follows you for the rest of your career if there's a data bank report. And you're going to have to explain that anytime you apply for privileges, anytime you apply for participation with a third-party payer, anytime you try to get a job. There are certain types of duties depending on the severity of the sanction that is imposed upon your license. If your license was suspended for a period of greater than 60 days or it's revoked, you have to notify in writing all of your patients the 120 days prior to in writing, and then 120 days forward orally. And sometimes it's very difficult, and it can kill your practice. It also can lead to, not only we're talking about departicipation, but it can lead to exclusion from the Medicare program. And that has some pretty serious ramifications in and of itself. A licensing action certainly can also have issues with your staff privileges, and you look at your bylaws to see what the ramifications could be. Some people, if they're just on probation, some hospitals won't take action, some will and say, okay, you lose your voting rights, and some will actually reduce your staff privileges. Your professional association could be affected. And the reason why that's important, some people say, well, I don't really care, but a lot of people have insurance. They've got good group benefits through their professional association, and that might be interfered with if they lose their membership because of a licensing action. Similarly, we already touched upon the loss of participation with certain PPOs and third-party payers. Blue Cross traditional program has, I mentioned criteria number 13, that it's so broad, one could argue that if you jaywalked, you violated a local ordinance, and therefore they could departicipate you. Generally, I find that they look, they departicipate you from the traditional program only when there's been something very significant, like a crime, a conviction of a crime. And again, we talked about, I know the trust program, a probation, just a simple probation on your license. You're going to get the letter from Tom Ruane from Blue Cross Blue Shield telling you that you're no longer welcome in the trust program. DEA registration often will follow. I find that the DEA registration is not necessarily like automatic. I've had cases where there's licensing actions, DEA looks into it, I then have an opportunity to explain to DEA, why they shouldn't be concerned. Maybe it had nothing to do with controlled substances. I mean, believe me, if you have a licensing action that's related to controlled substances, you can, yell to your blue in the face, they're kicking you out. But if a lot of times it's completely unrelated, and you can avoid any type of action on your DEA registration. Loss of board certification is also a possibility as well. And then we talk about exclusion. Again, that's a pretty lengthy topic, and I want to have a little bit of time for questions. And when I talk about exclusion, there's serious ramifications that if you are excluded, that hospitals will not hire you, practically speaking, because they can be excluded for hiring an excluded provider. And think about that, a hospital, entire hospital, not being able to bill a federal program, Medicare, Medicaid, some of the other, it's ridiculous. Okay, we talked about basically, this is my chicken or the egg cartoon, which is basically, what comes first, licensing or the criminal? Well, the answer is both, because certain criminal matters, and it's actually very important to take this into consideration. Again, the global resolution. I have had a case, this is years ago, where my doctor's license was summarily suspended. And so when it's a summary suspension, you just get a notice, and it's like, you got to stop practicing. I don't care if you got patients waiting in the hall. You got to stop practicing the moment you get that. Well, what happens is that you can have a special hearing to petition to dissolve that summary suspension before you get to the underlying case. Okay, just saying, hey, I can't, give me an opportunity to fight my underlying case, but I got to resolve this summary suspension. Well, if you want to convince the judge, the ALJ, that it's worth dissolving the summary suspension, typically you got to take the stand, okay? Because the judge is going to want to hear. There's usually not a lot of witnesses at that point. Your license, every day that goes by, you want that license back. So you rush in, and then you realize, and in this particular case, I petition, I'm in there, and I've got my client, and my client's ready to testify, and I look out in the audience, and I recognize a couple people. He's from the OIG, he's from the FBI, and I'm thinking, wait a second. If I have him testify, he may say something that will incriminate him, and now I got law enforcement out there looking on a criminal case. So you got to weigh that and say, I'm not sure if I want to take the chance of just trying to go for the summary suspension lift if I'm potentially going to bind this individual in a criminal matter. And so that's really an important thing to take into consideration. So I indicated a number of matters where the licensing case can lead to a criminal case. Obviously, and these are part of, I mentioned that under the Public Health Code, there's certain enumerated reasons for a disciplinary action. Well, here's a couple of them. Inappropriate sexual relationship with a patient, okay? That obviously can be a licensing, and it can very well be a criminal case as well. A pattern of providing the controlled substances without medical necessity, which has been touched upon by everybody. A pattern of fraudulent billing. These are specific sites within the Public Health Code that can lead to licensing, which then can lead to criminal. And a pattern of performing medically unnecessary procedures. Again, there's been some discussion about, well, how much? Well, you've got to really see a pattern in practice. We can all argue till we're blue in the face whether a particular patient visit was a 99211 or a 99212. But if you've got a practice of billing everybody on a level 5 E&M code, and you're basically, it's just a nurse seeing the patient, refilling a drug or something like that, okay, you got a problem. And it's not only licensing, but it's criminal. And then the chicken or the egg, it goes the other way around. Any criminal sexual, conduct, misdemeanor or whatever, you're basically going to find leads to the licensing action. It is intentional inappropriate destruction or alteration of medical records is huge, and that goes to what other people have touched upon, where I think Tom was saying, oh, hey, remember that one file that says do not disturb? I just need you to shred that or take care of that. Now you've committed a felony. Now you've actually destroyed a medical record. Or where you realize, oh, I better fill in some of the things. I didn't fill in some of those you start altering the medical record, you're potentially exposing yourself to a felony. Misdemeanor or felony involving fraud to obtain fees, and practicing under the influence of alcohol or drugs. So in conclusion, at least for this section, and we'd open up to questions, it's important to take into consideration the entire global perspective, because in the end, there's so many, it's so interrelated, and you've got the domino effect. I think it's very, very important to get appropriate consult from learned individuals from the beginning so that they can navigate these waters. And with that, I don't know if you have any other comments. Oh, you did have some comments about maps. And
I just have a couple of things that I want to make you all aware of, and I promise I won't take up a lot of time so that you can all ask questions. On this front table, I figured this was easiest. You're going to find 3 things. Just by a show of hands, how many of you are familiar with the Michigan Automated Prescription System that we've been referring to, MAPS? So a lot of people here. Is there anyone who's never heard of it, or this is your first? Okay. If you prescribe, this goes kind of to your comment earlier about prescribing OxyContin and controlled substances. The Michigan Automated Prescription System, the MAPS system, and most people just call it MAPS, and you hear the acronym and you don't really hear the long. We talk about MAPS all the time, particularly as attorneys who work in this field. And MAPS is a good way to be able to track if you suspect that you have a patient who, by no other reason than the fact that they want OxyContin, and you're thinking to yourself, well, your knee is hurt, it's not hurt that badly, or I don't see it, or you refer them, you give them referrals and they're not paying attention to you, and you have a patient who's constantly asking you, I need controlled substances, or I need this increased amount of controlled substances. You can absolutely, as a physician, utilize the MAPS system to check that patient to see if they're doctor shopping. I'm sure you've all heard on the news lately, you have to be living under a rock to not have heard at least one story on one of the exposés that one of the news stations does about how this patient went to 35 doctors in 60 days, or that this patient has obtained 3,000 tablets of OxyContin in the last 90 days. Just obnoxious amounts of controlled substances. Now, can they bamboozle a bunch of doctors? Absolutely. And the Attorney General's office isn't blind to the fact that, yes, you can be fooled as well. But when you continuously prescribe controlled substances to patients, it's really considered the standard of care now to check the Michigan Automated Prescription System and to utilize it to see if this person is doctor shopping, to see how much, if you go back through your medical records and you see on this person, gee, I've really increased this and they're using a lot of prescription medication, I've got them on all kinds of controlled substances, they don't want to see a pain doc, they don't want to see an addictionist, they don't want to go to referrals, I think red flags should go off. It certainly does at the Attorney General's office. And
I would dispute whether that is standard of care.
I would say, the Michigan guidelines for the use of controlled substance in the treatment plan doesn't mention the MAPS program. This is up here as well. It's also available online. And I also, just for your own edification, printed the Federation of State Medical Boards of the United States, because I figured that I'd get a little ire up. But I would challenge that although there's no case law, there's no judge that has said you have to use the Michigan Automated Prescription System. It is at your disposal. And I know when cases come into my office and I have at least 8 active, really large overprescribing cases sitting on my desk right now. On a regular basis, I have a rotating land of the overprescribing. This is an area that is going to get you into trouble if you do not do all of the things that your attorneys and all of the people who have mentored you over the years have told you to do with good documentation. And some people need to have lots of controlled substances. We all recognize that. But when you have a whole clientele of them, and as Thomas pointed out, these people flock to your office, I'm looking at that, and I'm one of the people who's reviewing these records, and I'm looking at the MAPS system, and you should be too.
I want to make one point, what Dan just said. It's interesting, too, because we all know that there is no book of the standard of practice. What is the standard of practice? Well, some people say it's one thing, someone says it's another thing. But I want to say that I actually have a licensing action where it's a family practitioner, and the state found an expert who, in writing, stated that it is the standard of practice for a family practitioner to do a psychological, when prescribing medication for a chronic pain patient, and I disagree with this, but I'm just saying they can find an expert out there who will say this, and the state has an expert that says that it is a standard of practice to do a psychological evaluation, to enter into a narcotics contract, and to check the MAPS program.